Morning is Yamamoto versus Roethlisberger.
May it please the court, counsel. Good afternoon. My name is Leon Walsh and I represent the appellant Amparo Yamamoto. We are here because of the trial court abused its discretion in dismissing Ms. Yamamoto's case with prejudice for fraud upon the court and thereby depriving her of her constitutional right to access to the courts. There's two issues. One, whether or not there was clear and convincing evidence that established that Ms. Yamamoto committed an unconscionable, calculated scheme intended to hamper the presentation of the defense's claim. Now, even if the court does find that there was fraud upon the court, the second issue is whether or not the sanction of dismissing the case with prejudice was appropriate. Now, the trial court's sanction was not warranted as it failed to carefully balance a policy favoring adjudication on the merits with the competing policies to maintain the integrity of the judicial system. Now, I think this case really presents an opportunity for this court to visit an issue that seems to be recurring in appellate courts and provide some more guidance to the trial courts, even as Judge Altenburn referenced in his concurring opinion in Ramey versus Haverty Furniture, a second DCA case from 2008. He indicates, I question whether the appellate courts have yet fashioned the appropriate test or guidelines for such a sanction. Now, the case on point that established the test that the second DCA applies was established in Jacob versus Henderson. That's the 2003 second DCA case. And the court, in its opinion, mentioned that we adopt the test succinctly set out by Chief Judge Griffin in Cox versus Burke, fifth DCA case from 1998. The test that was adopted was whether or not requisite fraud occurs where it can be demonstrated clearly and convincingly that a party has sentiently set in motion some unconscionable scheme calculated to interfere with the judicial system's ability impartially to adjudicate a matter by improperly influencing the trier of fact or unfairly hampering the presentation of the opposing party's claim or defense. Now, I pointed out Chief Judge Griffin in the test he set out in Cox versus Burke because that opinion was in 1998. 10 years later, Judge Griffin had another opportunity to revisit the issues, which was set out in Bologna versus Slanger. And I think his concurring opinion in that case is really significant that should be given some weight because in his concurrence, he says the bulk of these decisions now concern the failure to disclose mostly prior injury, prior pain, prior treatment in a personal injury case, especially back pain. Now, he says these decisions are often driven by what the judges believe the plaintiff's witness could or could not have forgotten. If the judges believe the witness could not have forgotten, then the information must have been fraudulently concealed. Now, he was persuaded that this was not a very good, accurate method for deciding who should be allowed to prosecute their personal injury claims and who should not. He hints on that a judge's understanding of memory is mostly anecdotal based on their own experience. He would guess that based on anecdotes that the memory of most judges is better than the average person. You know, and he goes on to mention that pain and medical treatment may be, for many, not so easy to recollect with accuracy. Now, the courts, in this case, like I said, applies a abuse of discretion standard And in Jacob versus Henderson, Judge Casanova discussed the decisions of trial court and how they're given less deference when the record on which the trial court's decision was based is the same cold record for the trial court. And that's what we have in this case. There was no live testimony at this evidentiary hearing on May 5th, but really...
You didn't ask for it.
What's that?
You didn't ask for live testimony below. Plaintiff's counsel said, I didn't want her to testify. That's why I filed this affidavit. Both of your briefs concede or agree that there was an evidentiary hearing. The Bologna case turned on the fact that there wasn't an evidentiary hearing, and that was the basis of the holding. So you need to tell us now whether there was an evidentiary hearing, because you've claimed it in your brief. Are you arguing now there wasn't?
No, and I'm saying the evidentiary hearing that was held, there was no live testimony. The trial court's decision was based on the cold records that it had before him.
And the affidavit of your client,
Correct.
which you, not you, but which the plaintiff's attorney below declared it sufficient.
Well,
And I don't see any argument in the briefs that she would have testified to something else.
And what I think I'm getting at is, basically, you have the same record that the trial court made in reaching its decision. And because of that, you having the same record in front of you that the trial court reaches decision, that the appellate courts give less deference. Because it's not like we can have, we can go back, or the trial court base its decision on how she testified her demeanor, and the fact that a lot of cases hinge on, okay, the plaintiff came here and they testified, and the trial court didn't find them to be credible based on their demeanor.
Sir, you can't come up here and make that argument based on cases that were reversed because there wasn't an evidentiary hearing. You can't come and make the argument, because in your brief you said there was an evidentiary hearing, but you can't come and argue to us today that there wasn't, therefore we must reverse.
And I'm not arguing there was not an evidentiary hearing. I'm saying there's no live testimony.
Yeah, but you can't, I don't think you can ask us to jettison an abuse of discretion standard and apply de novo review when plaintiff's counsel below avoided the opportunity to present live testimony.
Very well, and I think the court could have had the power to ask questions, but I believe, I guess I will concede that there was an evidentiary hearing in the courts. The standard of review is the abuse of discretion.
Counsel, let me interrupt you a second. Of all the cases that you're proffering we should use as guidance, is there any case where you have the litigant basically agreeing that she didn't disclose the information as this plaintiff did?
Well, I think a number of cases, the plaintiff submits affidavit kind of explaining the reasons why there was misrepresentations or omissions in their testimony.
In fact, this case is unique in that she says, my prior attorney advised me that I should not volunteer information. I took this at its literal sense and denied having the accident.
And I don't dispute that, but I think what's telling is there's a number of factors that come into play. One, there was kind of some confusion. English is her second language. Her deposition was taken in English, and if you read the deposition transcript in its entirety, it kind of appears that it's clear that she was misunderstanding things at times in her deposition. It doesn't read very clearly like she's a very intelligent and understanding all the questions, specifically in one point. That is correct. And I think the trial court, in their decision, really had difficulty in kind of assessing whether or not there has to be a prejudice in assessing the appropriate sanction, because they kind of asked the attorney there, is there any cases that, distinguish whether or not it's prejudice or the standards if there's been unfairly hampered. She even asked, okay, what if they had to take twice the amount of time to get that information? So she kind of discusses, and I think that's kind of why the problems that the trial courts have, because it's not very clear. And with that, I think, obviously, if the court's saying, okay, I don't think they were prejudiced, but they were unfairly hampered, well, then the next issue becomes, what is the appropriate sanction? And I think, obviously, the dismissal of prejudice is the death knell of a lawsuit, which you deprive her right to access the courts. And I think a lot of courts kind of distinguish whether or not the case has merits in itself and, determining whether or not the trial court's decision was appropriate. And I think with that, in the court indicating that is it prejudice or hampering, I think that's more conducive of the fact that there was other lesser sanctions that could be imposed to adequately address and ensure the integrity of the judicial system. They could have limited her ability to present some testimony about maybe her accident on her knee. That was something that the court could have done. And actually, I think what's telling is in the 5th DCA of Bass versus the city of Pembroke Pines, Judge Poland gives a dissent where basically he says, I fail to discern a deliberate attempt by the plaintiff to conceal information as she disclosed enough information to allow the city to easily uncover her prior medical history. And I think that's kind of what we have in this case with her disclosing the significant 2003 accident with the spinal fusion and then, that she was on Social Security disability. But why I point out the dissent in that case is because the Judge Poland discusses the available remedies which they could have had the right to vigorously cross-examine the plaintiff on her interrogatory and deposition responses to attack her credibility. They could have precluded a partial claim on certain areas of injury where discovery was hampered, i.e. the headache in that particular case. They could have fashioned specific jury instructions regarding the incomplete answers. And of course, we know that by the time of the hearing, defense counsel obtained all the information regarding the plaintiff's medical history. And I think that's kind of what we have in this case, and it was an issue that was kind of raised by the attorney was, okay, if you look at the record, it seems pretty clear that they had all the information going into Ms. Yamamoto's deposition. And what's even more telling is Chief Judge Griffin in Bologna talks about how we now have a system where defense attorneys are trying to game the system and basically set up this strategy of fraud upon the court. So rather than probing into all the questions and following up, they just kind of ask open-ended questions and leave it at that. Why? Because they don't want to probe a person's memory. And I think that's really significant because in this case, how can you say that they were unfairly hampered in presenting a defense if they have all the information prior to your depo?
But in this case, it goes back and it starts with the Florida bar rules about being honest and having integrity and being forthright, because the defense shouldn't have to go out there and do all this investigation, because when they ask him in this particular case, you ever been involved in a prior or subsequent accident, the plaintiff said no.
And I don't condone any of the...
But that's where it starts.
Well, and I agree, but I think...
This is the plaintiff bringing a cause of action, and they're not being truthful. That's where it starts, because the case law really... the cases don't turn on whether the defense was able to uncover this through their own independent investigation. Really, the key is the candor of the plaintiff. That's where it starts.
Well, and I think with that is the issues with the attorneys and not adequately bringing, this issue to light if there's false testimony, which that was kind of the concerns that Judge Laboda had. And I point that out because in the case of Jacob v. Henderson, you see that the trial court, I think it was the Lindsay case, mentions we don't impose a sanction based on the attorney's conduct. And I think that's significant because that's kind of what the court was considering in this case. Well, the attorney never acted and filed amended or updated the incomplete answers in this case. So I think the court's really making the decision more on the attorney conduct and not the actual plaintiff's conduct in the case. And I think her explanation that she gives as to why there was the omissions, confusion, the language, taking literal words, is certainly significant because the trial court, in its order dismissing the case, never really discusses why her explanation was insufficient, other than just saying we find her affidavit to be disingenuous, which if you kind of look at all these things and the public policy that we have of adjudicating these cases on merits, that's why we have these jury trials. We were 3 weeks away from a trial in this case, that we can have a jury come in, resolve it, because sure, there may be issues with, okay, what about her prior history, but her case has merits. You look at her interrogatories, and her bills are temporally related to the accident. You're talking significant medical bills in paragraph 13 of her interrogatories, $57,000 to the orthopedic surgeon. So now we have a case where, oh no, 3 weeks away from trial, we think you committed fraud upon the court. We're going to dismiss your case, impose the cost because it's been dismissed, when here we are denying her access to the courts when she has potentially a meritorious claim. And I don't think the sanction really fits with, I think there could have been other available sanctions that address the situation, maybe in the discovery context, assessing attorney fees. But no, we're just going to, sound the death knell of this lawsuit and dismiss it with prejudice, deny her access to the courts. And I think that's obviously why the appellate courts continue to see so many cases involving this matter, is because the trial courts struggle in determining how to make these decisions. You're basically getting the luck of a draw. If a judge thinks you should remember this, well, I think you committed fraud. And I think that's why the timing of all this is significant. If you look at other cases...
Mr. Walsh, excuse me, if you want to reserve up to 5 minutes for rebuttal, I just want to tell you you're up to about 15 minutes
okay.
plus.
I would like to reserve 5 minutes, but lastly, I guess I would just kind of conclude on the fact that, really what we have here again kind of goes to the fact that we have public policy. That's why we have these juries, and I think it's significant in the Jacob v. Henderson case, in which the judge touches on the very fact that we've trusted juries. It was from that 1978 opinion, Francois versus Harris, a 3rd DCA 1979 opinion. In all but most extreme cases, our system entrusts juries with the ultimate decisions as to whether claimed injuries are genuine or not. Our experience has demonstrated that juries deserve this trust and that they are well able to discern the truth and to render judgment accordingly.
Thank you, Mr. Walsh. Ms. Klein?
In decline on behalf of the appellee, Ms. Roethlisberger. One thing that hasn't been addressed by opposing counsel, and I think is critical in this case, is the fact that his law firm was not only present at that deposition during which the plaintiff lied and also assisted the plaintiff in filling out the interrogatories, but that firm was also counsel in relation to the 2015 accident that the client never disclosed. So we have a law firm that was well aware of the true facts at both the time that the interrogatories were responded to and during the deposition. And the law firm never disclosed the true facts.
Maybe the target of any punitive action is not Mrs. Yamamoto.
Well, respectfully, Judge, I would disagree with that. There was a similar case, Hogan versus Dollar Rent-A-Car, that we had cited in our brief, 783 Southern 2nd 1211 4th District 2001. In that case, the plaintiff had subsequently injured himself, tripped and fell outside of his attorney's office. His attorney knew of the injuries, never disclosed it or counseled his client to disclose it at any point in time. The DCA found that that fraud would be attributable to the plaintiff, as is the case here. I'm not saying certainly that the plaintiff was not equally, if more, at fault. I'm just saying that one of her excuses was that she received bad legal advice from her counsel, the same counsel who was present at the deposition and the interrogatories, and that she misunderstood her counsel's advice not to volunteer anything to mean that she shouldn't answer the questions truthfully and honestly. Obviously, that excuse is no excuse at all. And even if it was, we know that her counsel was right there and could have very easily and promptly prompted her to disclose what he knew to be the truth, and he did not do so. It is also extremely significant, as the panel has already noted, that the plaintiff had the ability to testify live at the evidentiary hearing. And in fact, not only was she there, but a translator was also there. Again, this law firm specifically said, I do not want my client to testify. I believe that was on page 350 of the record on appeal. And as the court also knew, that that same attorney waived reading and correction of the deposition transcript. In any event, if there was any question as to the validity of the plaintiff's affidavit and or her credibility, it was incumbent upon the plaintiff and her counsel at that point in time to permit the court to view her live, to ask her any questions that the court might have had, and to make the record, if they were going to pursue this avenue of appeal, to make the record that the record was not the cold hard record, but that the court abused its discretion in making a credibility determination that the live evidence did not justify. Having failed to do so and having affirmatively waived the right to do so, as Judge Sleet had noticed, we agree that certainly this is not going to be a de novo review. This court is charged with determining whether any reasonable judge could have made the same decision on this record, and I believe that there really is no legitimate question that the trial judge in this case did not abuse his discretion. Just briefly, the other argument raised by opposing counsel and in the plaintiff's affidavit was that she had some kind of language barrier. The court correctly found on the record that there was no language barrier in this case. She did have a translator at her deposition and chose not to utilize that translator. There is nothing in the deposition indicating that the plaintiff had any problems understanding the questions. And once again, with that same counsel there, if it appeared that his client was misunderstanding a question or did answer untruthfully because of a misunderstanding, again, I would suggest that counsel had the duty and the obligation at that point to ask for a break of the deposition and to counsel his client accordingly. He did not do so. He waived the right to read the deposition, and never until a month after the motion to dismiss did counsel ever correct the record and disclose the two physicians that his client went to after her 2015 accident. Finally, the argument that's been made, and it's been made in other cases as well and soundly rejected, is that where's the harm? First of all, as the trial judge correctly noted in this case, that's not the test. The test is whether or not the opposing party was unfairly hampered in their litigation of the case. The argument that a plaintiff shouldn't be punished because the other side was successful in uncovering faulty or untruthful testimony is ridiculous, and the court so found in Cox versus Burke, which is at 706 Southern 2nd 43, 5th District, 1998. In all of these cases, the opposing party ultimately unearths the truth of the matter, which is how the motion to dismiss comes to be. To bail out an untruthful litigant because the other side found them out is as The judge said in that case, not only ironic, but really contrary to public policy. The mere fact that the other side is diligent enough to uncover things that the plaintiff has not properly disclosed in response to direct and clear questions does not inure to the plaintiff's benefit. The defense in this case was clearly hampered in its presentation. The defense lawyer noted to the court that it cost him $50,000 in discovery costs, and given that there has been no argument that the defense was not unfairly hampered in this case, this court must affirm the trial court's dismissal on all points. Thank you.
Thank you, Ms. Klein. Mr. Walsh?
And I guess I'd like to spend some time just focusing probably more on the sanction that was imposed, but I guess before I do that, I'll turn to the Bass versus the City of Pembroke Pines case, 991 Southern 2nd, 2008 50 CA case. And that's kind of where the dissent by Judge Powlin talks about, perhaps some of the responsibility here lies with appellant's trial counsel. While the appellee should not have to suffer because of its opponent's counsel's lack of diligence, it is well settled that a party should not be unduly penalized for their counsel's lack of attention. See Lindsay versus King, 894 Southern 2nd, 1058, and that's a 5th DCA case, or actually a 1st DCA case from 2005. And I think, a couple things here is they made a big deal about the interrogatories that were filed on February 23rd. If you look at the record itself, while it wasn't really raised, I had a hard time distinguishing whether or not the answers were notarized on January 13th, 2015. They always focused just clearly on the date that they were actually filed. So that I just wanted to kind of bring that to your attention. But ultimately, I think the courts have kind of made a distinction when a plaintiff has made a false foundation that the case rests on in its entirety. And I think that's in Aode versus the Mobile Oil Corp., which they dismissed the case because there the plaintiff forged an entire purchase agreement for the Mobile Oil Corp. And then I think you have the other cases where when a party's actually doing something affirmatively, such as revising medical records that are the subject of lawsuit, that sure, there's fraud upon the court and the appropriate sanctions dismissal. But I think, again, the biggest thing is there was other available remedies to the trial court that could have been imposed that would have certainly met the needs and ensured the institutional integrity of the system by, again, going back to some of those lesser restrictive sanctions, costs, attorney fees, whatever the case may be, because we were 3 weeks from trial, so I think that's really significant. But again, this is, in Bologna, they did a very good job saying, we've tried very, very hard to discuss the circumstances that warrant this extremely harsh sanction, which obviously, even though they did a very hard job trying to express it, it seems like this continues to be problematic for trial courts because these cases keep coming up on appeal. But I think with that, it really highlights the fact that this is we have impeachment. We have all these other factors that we can bring these issues to light. But at the end of the day, let's have the juries do what their function is to decide these cases rather than having an evidentiary hearing for an hour or so, end up making the decision. Because there was potentially merits to this case, and I think the jury could have been as well. I know the jury is better versed at making the decisions about what is actually genuine and what is not. And that's what our system relies upon. And I think that there certainly could have gone into these issues on impeachment and vigorously impeached the plaintiff at the trial. And I think that is significant, along with the timing involved in this case. It's not like some of the cases where you have somebody misrepresenting an accident 4 years ago or 2 months ago, like a lot of the cases. Here you got a person that has an extensive medical history going back to 2003 with a spinal fusion. For her to remember every doctor that treated her, I mean, is kind of as she mentions, I lumped them all in kind of with my disability that I indicated. She gave everything that, there was no attempts to conceal the information in there. She gave the information that would lead to the discovery of all this, and I think that's certainly significant. She's not out there trying to conceal all this, and I think when it's all said and done, I think we have the jury system so we can use it, and I think that's what really we need to tighten up the standards, provide more guidance, and assist the trial courts, because this continues. There's so many cases on there, and I just think that when it's all said and done, the evidence doesn't clearly and convincingly demonstrate a calculated, unconscionable scheme intended to interfere with their ability to hamper the presentation, and that goes to her disclosing information that would have led to all this information. And lastly, I would just point out that the $50,000, I believe that was for the total attorney fees. I would defer to, the record itself. But again, this is getting 3 weeks before trial. So I just think that, again, the court abused its discretion. There was not clear and convincing evidence, and we believe the trial decision should be reversed and remanded for further proceedings. Thank you.
Thank you, Mr. Walsh. Thank you both. That concludes our docket for this morning, this afternoon. We are adjourned.